it's really an honor to bring together hard and soft law as we think about the end of this conversation. And we end our time together by discussing the crucial importance of normative instruments in global health. And I'm delighted to moderate this final session on human rights and global health policy. My name is Benjamin Meier. I'm a professor of global health policy at the University of North Carolina at Chapel Hill. And in moderating this conversation, we bring together two inspiring senior colleagues, scholars in a hybrid discussion around these issues, speaking in the room and online. And in speaking about the 2030 Agenda, the Sustainable Development Goals and its implications for global health law, we're joined in the room by Stéphanie Dagron. Professor Dagron is a professor of international law at the University of Geneva, where she holds joint appointments in the law faculty and the medical faculty, and research specializing in international, European, and national laws around health and social security. And then speaking about human rights law in global health law, asking whether these two legal regimes are really just ships passing in the night. We'll then hear online from Alicia Yamin. Professor Yamin is a senior fellow at the Petrie-Flom Center for Health Policy, Biotechnology, and Bioethics at the Harvard Law School, a senior scholar of global health education and learning at the Harvard University's Global Health Incubator, and an adjunct lecturer on global health and population health at the Harvard T.H. Chan School of Public Health, alongside being an affiliated faculty member of the Department of Global Health and Social Medicine at the Harvard Medical School. And beginning with Professor Dagron speaking about the 2030 Agenda, please let me now ask you to begin your intervention. Thank
you. Thank you very much, Ben, for this introduction. Just
yes.
1 second.
And so in thinking about these issues, one of the things that brings them together is the ways in which we continue the conversation around this distinction between hard and soft law. But we begin to think about two different areas of law on both hard and soft that help us to conceptualize the ways in which we're building legal regimes for the future. Thinking about the ways in which these normative frameworks are helping to guide us in structuring these legal regimes, bringing together the world largely around soft law frameworks, and thinking about the ways in which we can focus on the most marginalized, the inequities of a globalizing world, and the ways in which nations need to come together to address these common harms through collective action. And now let me turn it over to Professor Dagron to begin us in focusing on the Sustainable Development Goals as a global health policy framework.
Right, thank you very much. And I'm sorry for this technical problem. So I'm going to talk about the 2030 Agenda for Sustainable Development that has been adopted in 2015 by the UN General Assembly. This agenda is a non-binding law, and but it is also a very coherent action plan. It has been described as a powerful strategic approach, and I quite agree with this description. That has been chosen in order to reflect the fact that the agenda offers a simplified analysis of the complex economic, political, social, and environmental challenges we are facing. This approach authorizes the assessment of progress and therefore facilitate policy planning. A huge number of indicators have been adopted and are part of the agenda. And this approach proposes as well a deadline and therefore encourages states to adopt new politics and urgently. The focus of my talk will be on the impact of this agenda, the impact this agenda might have on global health law, and on the use of international law instruments to address global public health issues. And I will formulate a few comments. My first comments are quite positive. The agenda adopts a broad definition of health and proposes a long list of global health issues to be addressed urgently. And this list is really interesting because it confirms the idea that global health law has a broad field of application and touches on many issues that are directly or indirectly connected with human health. And that was not really the situation until today. Millennium Development Goals that were adopted in 2000 reflected a very medical approach to health, and as a consequence, you have a restricted area of action, so to say. So the SDGs propose or have adopted one goal on more specifically on health, and the different targets that are connected to SDG 3 on health are related to medical issues, but also to other kind of issues that are more system or structure issues like road safety, environment, health system, financing, the concept of universal health coverage, and also prevention of for NCDs and epidemics. Connected to this first comment, I would like to formulate a second one concerning the strong links established between SDG 3 on health and other SDGs. These links confirm but also explain, in my view, the complexity of global health law as a fragmented body of normative international instruments that do not only address public health issues, but also issues that are within the realms of other fields of international law, such as environmental law, trade law, labor, and social security law. And this strong connection has been reaffirmed again and again. I just want to refer to a resolution adopted by the General Assembly in 2019 on universal health coverage that says, well, health is a precondition for and an outcome of the social, economic, and environmental dimensions of sustainable development and the implementation of the 2030 agenda. So it's really clear. Now, I have a few negative comments to formulate. The first one concerns the choice of targets and indicators for the implementation of SDG 3 on health. And for me, this choice reflects a rejection of law as a key instrument. So there is first a refusal generally to rely on law as an instrument for the implementation of SDG 3. So you have 13 health targets, and only 2 refer to hard global law health law instruments that are the Framework Convention on Tobacco Control, and implicitly the international health regulations, the EHR, are only mentioned in the list of indicators. And then you have a third target that refers to the TRIPS agreement adopted by WTO. And that's it. We don't find any more references to soft law instrument or other legal instruments. What is interesting also to see is that even for these targets that refer to international law instruments, well, the indicators that have been chosen to measure country performance in implementing UFC do not refer to law. The indicators are only related to, well, you only find traditional medical indicators, and with that I mean mortality rates or percentage of infection within a population, or you find economic indicators such as those chosen for the implementation of UHC. Another element to be mentioned illustrating this rejection of legal instrument is secondly, the refusal to refer explicitly to international human rights law as an instrument for the realization of the different goals. The agenda does not make use of a human rights language with the exception of the preamble and also targets 4.7 on education. And I must say that this approach is surprising because, well, UN agencies since 2003 have made huge efforts in order to advocate for a human rights-based approach, at least in the field of development. And the absence of human rights language is also not really coherent regarding actually declarations and resolutions that have been adopted after the adoption of the Agenda 2030, and that refer again to human rights of the right to health as being the fundamental basis for the different public health issues that are concerned. So you find again in this resolution 2019 on universal health coverage, well, the General Assembly affirmed that the right to health is the central value here to be respected. Third, the rejection of law is problematic because law is an essential element for the realization of all health strategies. So law is essential to evaluate and approve safe medicines or vaccines. It is essential to create a safe environment or develop healthier workplaces, for example. Now, a last negative comment that concerns the institutional architecture in the field of global health. In 2019, the General Assembly launched the Global Action Plan for Healthy Lives and Well-being for All, bringing together global health actors in order to support countries in delivering on in SDG 3. There are 13 GAP signatory agencies, including 3 standard-setting agencies, WHO, World Bank, and VIO. You find 2 public-private partnerships, Gavi and the Global Fund, and the rest are UN funds and programs specialized in financing. So the gap is interesting. It reflects an attempt to counter difficulties that have been identified in the field of global health since at least 2 decades, and that resulted in fragmentation because of the implication of too many actors. And well, countries were receiving conflicting advices from different actors and experiences of duplication of efforts and fragmented channels of funding. So that was considered as problematic. And the gap encourages collaboration between actors active in the field of public health, development, and humanitarian activities. And that is an interesting answer to fragmentation. However, it is to be noticed that, well, you find only 3 out of 13 actors that are standard settings actors, WHO with a large mandate, World Bank with no mandate at all in the field of public health, and the ILO, and I consider the ILO as having a large mandate in the field of public health because WHO is responsible for occupational safety and health, and also for the development of social security systems. However, it was mentioned when the ILO joined the GAP only in March 2021, and it was specified that the ILO joined the GAP with regard to its competencies in the field of occupational health only. Second remark, none of these agencies, but the 13 actors building the GAP, none of these agencies or actors have been attributed a leadership role. And that's in comparison to other groups, it is something different. And this seems, in my view, to question not only WHO's leadership position in global health, but also the importance of standard setting agencies more generally. What is missing as well, you don't see other standard setting agencies like WTO or human rights agencies like the UNHCR. So to sum up, I want to mention two elements. The analysis of the Agenda 2030 and more particularly of SDG 3 on health reveals that law has been sidelined by states, preferring to concentrate on medical and economic strategies, but also that specific institutions have been undermined. The agenda is surely not the cause of the particular characteristics of global health law that is fragmented, incomplete, and sometimes contradictory, but it does not encourage states to implement existing instruments or to resolve potential conflicts. And to end up on a more positive note, I would say that the agenda may have diverted the efforts and human and financial capacities of states away from their already accepted legal engagement in the field of public health. But it has also shown that there is a strong, or what can a strong and coherent political will achieve. And a strong and coherent political will is also a central condition for the development of new legal instruments and for their implementation. Thank you very much.
Thank you so much, Stéphanie. As we think about these larger questions of what role human rights play in our global health policies, let me now turn it online to Alicia Yamin, who helps ask the larger question beyond the SDGs. Are human rights law and global health law ships passing in the night? Alicia, over to you.
Thanks very much, Ben. And thanks to Lisa and Ben and everybody for accommodating an online presentation. I really wish I were there in person. And I have a number of questions for Stéphanie, so I hope I can be put in the queue when we get to the conversation phase. So I took the title, Ben asked me for the title and I responded very quickly, but I took the title from an influential article that Philip Alston wrote about the MDGs and human rights in the Human Rights Quarterly in 2005, because I knew I was following Stéphanie. And he sets out a number of different alternatives for how to think about the relationship between human rights and the MDGs as complementary, duplicative, inconsistent, and goes through the various critiques. And the conclusion he really gives is that it is just very important for human rights scholars and actors to pay more attention to the MDGs. It was a paradigm that ostensibly set out and coded a notion of human development, centering the eradication of poverty as opposed to just economic growth. And human development and human rights are very complementary approaches to human flourishing. And similarly, if we've learned anything during this pandemic, it is that population health is needed for a global order in which all can enjoy their human rights. But, and this comes out in the Alston piece, and it's something that I will dwell on, paradigm blindness famously leads to policy failure. When I teach human rights at Harvard Law School, and economic and social rights is really my field, so that's what I teach mostly, I often cite a Black feminist essayist and activist named Audre Lorde, who famously said, we can't use the master's tools to dismantle the master's house. And that is in many ways what using human rights progressively, intentionally, deliberately is like, because the law itself offers an inherently conservative set of tools. The law itself structures our grossly unequal world as well as the representation of it. I'm not quite as fatalistic as the statement from Audre Lorde suggests. I think we have, there is, in Catherine Sickink's words, evidence for hope. We've made an enormous amount of progress in converting health into a legal, justiciable, enforceable right. We have made an enormous amount of progress in the last 30 years of articulating what it would mean, which is not at all self-evident, to take seriously health-related rights in not just laws and policies, but in budgets, in program design and implementation, in monitoring and review exercises. And those are the famous human rights-based approaches to health. There's an enormous amount of contestation about the elements of those, but I think we have made significant progress. Where I believe we've fallen short is showing that deploying rights in health can really create a more egalitarian world. The world that the pandemic struck was an institutionalized social order where countries were racked with debt, layers of austerity. There was gross inequality. A handful of billionaires had as much wealth as half or 60% of the population. And there was general legitimacy crisis in democratic states. So why is that? Part of the reason I think that is that we often concentrate in human rights of this sort of not necessarily linear, but isolated narrative of constructing normative scaffoldings and institutional and procedural scaffoldings. But while we were doing that, while we were progressively articulating health rights, articulating who could be full and equal members of polities, et cetera, other branches of law were also developing in many ways in an opposing direction. So I would mention tax laws, securities laws, antitrust laws, trade liberalization and intellectual property, and a host of other laws that were imposed on countries in the global South with structural adjustment, privatization, et cetera. So I would, and I'm going to say that I'm really talking about global health law. I'm talking about the IHR, the revision of 2005. So I would put that other branch of law, IHR, in that category that was developing at the same time. And I just want to point out three ways in which we might be cautious about harmonization. One is content, two is governance, and three is remedies. So in terms of content, the revision of the IHR that came out in 2005 was started in 1995, not coincidentally when the WTO went into effect, that had biting enforcement power on intellectual property, something that really didn't exist across the global South earlier. HIV/AIDS was a considerable problem across the globe and shaped this notion of global health security, and then later SARS, CoV-1, and 9/11, of course, happened, and there were health-related anthrax outbreaks. My own husband was contaminated with anthrax during that time, shaped this concept of global health security that was necessary to sustain the increasingly financialized neoliberal global economy, where we just had to have unfettered exchange of money and commodities. So many people point to the protections for travelers as evidence that there is harmonization between the IHR and human rights. And I am skeptical of that because the protection of travel and trade, of course, is also necessary to sustaining the global economy. And surprisingly, this has not really been emphasized during the pandemic, but the amount of travel at a time where we face not just a health crisis, but conjoined political, ecological, health, and economic crisis. The amount of travel since H1N1 has increased by airplane, has increased by 80% more than population growth. There are 2.8 billion new air travelers each year between 2009 and right before the pandemic. So that is the landscape, the protection that we are hanging on for, saying that this is protecting people's human rights. And I can talk about Article 44 as well. So the second area where I would be cautious is governance. Human rights depends upon democratic political economies where people actually come together in debate, in dialogue, and the decisions that affect their lives are justified to them as equal, diverse members of the polity. That, today we've seen, again, deepening legitimation crises. The administrative state has become indifferent and unresponsive to many citizens. But the global health law really encapsulates and enshrines a very different understanding of governance from a global institutional order, which is not unlike the kind of governance encoded that Stephanie was talking about in the SDGs, where indicators are monitored by global institutions, and they then have an effect on national strategies and national actions. And it is very similar, in fact, based on the idea that global institutions like the IMF and the World Bank and private commercial banks would govern from a distance through adjustments in inflation rates or interest rates with respect to the countries on which they had imposed structural adjustment. So I think that governance at a distance that is likely to deepen in any pandemic treaty we see is actually quite anti-democratic. And I can talk in the discussion about ways to get around it, but that is not consistent with, it can be made consistent through the institutional structures within countries, but there is a tension there between human rights and global health governance. And the final thing I would say is that the remedies have a very different purpose, right? The IHR now has very weak, if existent, remedies or sanctions, but the idea is to detect an outbreak and to negotiate how to stop that outbreak, to return the situation to a status quo. In human rights, the idea is not to return the status quo, but to transform, to catalyze a much broader transformation of the colonialist, patriarchal, economically unfair, sometimes politically tyrannical status quo. So I see the ultimate objectives as also being quite in tension. So what do we do if that vision that there are significant tensions is accurate? What is the posture of human rights actors, scholars, practitioners? Well, I think we should be one, we should be cautious about pasting on human rights language. We've seen that that does not work in the MDGs and SDGs. We've seen that that does not work in social constitutions across Latin America, where what Gargarella calls the engine room of the Constitution, the way power is actually exercised, does not shift. So I think we should be cautious about that and buying into that and being bought off by that promise. And I think we have seen efforts where civil society has pushed that the institutionalized social order in global health has shifted. HIV/AIDS is the perfect example. But I think it is possible. And frankly, the difference between the Millennium Development Goals and the Sustainable Development Goals is largely the result of civil society activism. So I think, and the transsectoral conferences of the 1990s that were so influential despite being soft law. So I think there is evidence of where we can change and push. But we are at a delicate moment where human rights is very under critique for being complicit in many of the subordinating forces around the world. And I think we should be cautious about looking for harmonization that may not substantively pan out. Thank you.
Thank you to both Stephanie and Alicia for these helpfully interconnected discussions. Alicia begins by recognizing that human rights were missing in the MDGs, described then as ships passing in the night. The 2005 revisions of the IHR have served to reinforce notions of global health security to the detriment of human rights. And Stephanie recognizes that human rights have remained disconnected from the implementation of the Sustainable Development Goals, despite, to use Alicia's phrase, the pasting on of human rights language. How do we make human rights real? And so I want to begin the discussion by asking both of you that you're concerned about legal regimes and their conflicts, the ways in which this conflict between legal regimes has undermined human rights in global health. In this case, this conflict between legal regimes is being driven by the proliferation of new actors in the global health space. And in the aftermath of the COVID-19 pandemic, I imagine we will see a further proliferation of new actors entering this space. To what extent do you think this proliferation of actors in global health and the rise of international organizations well beyond WHO entering the global health policy landscape, to what extent have these new institutions undermined efforts to mainstream human rights in our global health law efforts? Alicia, can I begin with you?
So I'm actually not entirely sure I understand the question, Ben. I mean, obviously, different institutions play different roles. I would historically cite around the time of the MDGs, the Bretton Woods institution, the World Bank in particular, became more important actors in global governance than the UN institutions. And that had a very big dramatic effect on health as well as many other human rights. Of course, the other thing that happened in the 2000s was enter stage left Bill and Melinda Gates. And that also had an enormous effect on the democratic deficit in global health governance. But I'm not sure if that's what you're pointing to, or the institutions of the ACT-A now before COVID and COVAX and CEPI. So I'm happy to talk further, maybe after Stephanie gets more clarity.
And I think that's what I'm speaking to, given the past proliferation of these institutions, to what extent does that bode well or ill for the rise of new actors like ACT-A, like COVAX, like the rise of new institutions yet to be determined? Stephanie?
Yeah, thank you. I am not sure the rise of new actors is the cause of deficiencies in the number of legal instruments that will be decided. In the field of health, and it comes also historically from the definition that the medical approach that has been adopted. Traditionally, there were just too few legal instruments that have been used. I think you can't, it's difficult to accelerate now. Maybe it's difficult to accelerate because you have that many actors and you have to actually try to include them in negotiations. That might be a difficulty. But it's not because you have too many actors that you have difficulties to develop new solutions or new legal solutions, in my view.
Thank you. We have two questions in the room from Lisa and Gianluca, and as has been our tradition thus far, I'll ask you both to state your questions and then turn it to the panelists.
Thank you, Stephanie and Alicia, for your really thought-provoking presentations. I think the relationship or the lack of relationship and the dialectic between global health policy and human rights is such an interesting, it's such an interesting kind of one-way dialogue, you know. There are ships passing in the night, but not for lack of trying from human rights side, you know. So human rights is always taken, for a significant amount of time, taken global health policy as significant standard setting. I mean, the declaration of Alma Ata, ICPD, Beijing, they've given us really fundamental concepts and paradigms and frameworks for how we understand and articulate the right to health. And I think in the other direction, we've been a little bit more of sort of the unspoken suitor who I think there's a little bit of a Trojan horse quality to the way that human rights has influenced global health policy, in the sense that I think that the right to health has had a clear influence on concepts like universal health coverage, but we're just not it's not acknowledged to the extent in possibly just because of the sort of real politic of how global health policy is made. So I'm very interested to get a sense from you of what you know, I think in global health policy, we've seen policy be more effective than human rights. You know, this very soft articulations of norms sometimes achieve far better impacts in terms of policy influence at the domestic level than the International Covenant on Economic, Social and Cultural Rights is. And I wonder if you'd be willing to speak to that. I'll quickly just put one other question to Alicia. I think the framing of human rights as the master's tools is really thought-provoking. And I hear a lot of skepticism from you about the potential for law and global institutions to achieve transformative aims. Is there a way, is it just not a legal question, the realization of human rights, in your opinion?
Thank you. Alicia, I loved your sort of critical studies approach to the IHR. I didn't see them that way, and it's very, in a way, thought-provoking. So never saw the coincidence between the birth of WTO and the start of the process of revision. So if I heard you correctly, it's almost like a part of a larger plan to keep the world safe for commerce and travel. And it can definitely be, you put the dots together, it can definitely be a lot to say about that. But so does that political agenda behind, in a way, do you think it created a flawed IHR, that they were too driven by geopolitical, economic interest to be a serious public health tool? I don't want to be an advocate. I'm just curious whether you think that that larger agenda behind it led eventually to not what we would have needed. The politics prevailed over proper public health and international law approaches.
Alicia, do you want to start?
Sure. So I guess I'll start with Lisa's question about whether there's a place for global institutions in transformative change. So my view of the way normativization occurs in human rights, the way they become, and this goes to the theme of soft and hard law, is that there is a very recursive relationship between what happens at the domestic. I mean, I work largely with constitutional courts, with activists on the ground, and I also have worked at the UN level. But the way that there is a recursive relationship in taking universal notions, for example, in the transsectoral conferences of the 1990s, which were soft law, and vernacularizing them, to use Sally Mary's language, through a whole series of institutions and processes onto the ground. That then feeds new developments at international level. And sometimes that dialectical process produces significant transformation. I mean, I think that some of the transformative constitutionalism is out of favor these days, but some of the jurisprudence from the South African Constitutional Court, the work of some iconic courts in Latin America, even some of the work of the Indian Supreme Court and others, has really influenced greatly the development of international law and has also pushed the creation of international institutions. I don't think we need to fetishize our current international order and international institutions, but that is a process that comes, in my view, most productively from this sort of messy, recursive interaction, often legal experimentalist approaches, and not through top-down mainstreaming. I think top-down mainstreaming tends to produce human rights experts who are marginalized in the larger institution. And that vision of, I really fundamentally believe in human rights praxis where the agents who are engaged, whether they are lawyers or whether they are social movements, have a role in defining the contested nature. There's no right that is more unstable normatively than the right to health. Defining that and using it to advance their ends. And I think that lends itself to working across movements, not isolating health from environment, for example, but working across movements at national level and reshaping global institutions. So that would be my first response to your question. I am skeptical about capital H, capital R human rights that I feel have moved in an overly bureaucratized direction, yes, but I'm not skeptical about the allegory of what it means to be human in a democracy that little h, little r represents. The question of Gianluca. So I do generally, that might have been a little bit strong what you said about reflecting back what I said about the IHR, but it is pretty close to what I believe. I think in Latin America, where I spend a lot of my time, I work with Latin American lawyers and Latin American public health people. I'm part of different Latin American groups. There is a profound aversion to the IHR, to the issues of colonialism and an incursion into national sovereignty through this health lens of reshaping national security controls from the United States using health, and really a very profound fear, I would say, of how this whole next pandemic treaty and revision is going to work out. So, you know, a lot of how we see the HR depends on our positionality, and I am sympathetic to that view from Latin America.
Okay, thank you. And I need to turn briefly to Stephanie to speak, and then I'm cognizant of time as we wrap up and turn it back to Lisa.
Okay. I will try to be very short. So what I understood from your question, Lisa, is summarized, well, is that the strategy that has been adopted in the SDGs more efficient than a human rights strategy? And well, it's hard to give an answer to that today, because when you look at the results of you know, analysis on implementation of the SDGs today, after 2 years of pandemic, the results are catastrophic. So it's difficult to give an opinion regarding that. But what I can say is that the strategy adopted is concentrate on very, very essential and very minimal obligations towards states. And in my view, that's not really in line with the ambitious vision of the agenda that is titled actually Transforming Our World. So I'm quite skeptical about that. And I have a point to make regarding the remark by Gianluca saying that, well, the HR have been oriented by politics.
What she said.
Okay, what Alicia said. I have to say, well, I have analyzed the case law of the European Court of Human Rights regarding health and social issues. And in many case law, what you see is that the Court of Human Rights is very prudent and does not want to engage with social issues, health issues, saying all along, well, you know, states have a large margin of appreciation in this domain. And I think, you know, discussing treaties is something states do together, and states are very protective of their domain of competencies, and health is extremely protected in this sense. So yes, influence of politics, but more maybe this special domain of public health is also driven by the idea that states want to stay sovereign and decide for themselves. Thank you. I stop here.
And so this has been a really helpful final conversation, bringing together soft and hard law regimes to understand how they influence global health. Please join me in thanking our final panelists. Inspired by these conversations, please let me now turn it back to Lisa Foreman to help close our session together at the Global Health Law Conference.
Well, I think it's a fantastic sign of the extent of the passion around the table that people don't want to stop the discussion. So I want to thank my colleagues and our special guest, Sam, for a really fantastic morning of engagement. We've been going for, this is our 4th day of discussion. So the passion in this room, the commitment is really extraordinary. And I want to thank our online audience for joining us. And we are very pleased to be recording this for posterity for those who will be joining at a later stage. Thank you, everybody.
Thank you. Bye-bye to Judith and Alicia.
Yeah.
That's not fair.